No, that's it. That's all I have at this time.
Attorney members, do you have any cross-examination for Mr.
No
Ross?
cross, no.
Does the board have any questions for Mr. Ross?
No, you laid it out pretty nice, thank you. Both of you, it's just fantastic. Looks pretty simple. Go to the clerk's office, find out what they're in.
We'll get into that.
Oh, pardon me.
All right, so we'll move into closing statements then. We'll start with the objector.
Sure. Just briefly, as noted, even with Ms. Johnson's testimony, she's not changing her party status. She intends to remain a Democrat, and so the signature should be invalid for Mr. Ross. Regarding all of the signatures, we're agreed on the facts. We are agreed that these are registered voters and that they live at these addresses, but these addresses are outside of the third ward. And this map is the direct map from the county board, or excuse me, the city council minutes. You have a nice little hyperlink actually that we can click on and open up and find the exact map and where the ward is located. They were previously in the third ward, but they are no longer, and this is the map that controls for this coming election. And then, as Mr. Ross has already agreed, for objection G and objection J, those should also be stricken. So for those reasons, we ask that all 10 objections be sustained and Mr. Ross not be approved to be on the ballot in April.
Just to verify, we had 8 more than he needed, but these are 10 of them that are.
Well, so there is actually 33. The fourth, or the last page, there's one that's like crossed out and then written underneath it, so it's 33, not 34.
33, okay. Yeah. So he's 8 over then.
Give or take.
Good, yeah, if they were good.
Yes.
If they're not good.
Then
Now
it's
he's on
200.
throw out, he's out.
Yep.
All right.
Mr. Ross, do you have a closing statement?
No, I don't have anything at this time. I just, well, basically, it's, we went out, we surveyed our petition, and my understanding is these people are always in the third ward, they've been in the third ward, so, we'll go from there.
And one housekeeping item before we close this there. Mr. Ross presented a bunch of documents here. There were no objections as far as their validity. If there would be a motion to enter these in as candidates exhibit A.
So moved. I'm sorry, can you say that again?
To enter Mr. Ross's documents into evidence as candidates exhibit A.
Second. All those in favor? Aye. Opposed? The motion passes.
Right, so that will close then the evidentiary portion of the hearing, and now it's time for the board to move into deliberations there. So, initially, I guess I'll try to help, what your guys' discussion needs to be there. So, Mr. Ross is required to have 25 signatures, right? So the challenge is basically that 10 of the signatures are not good, therefore he's gonna drop them, and it's gonna bring him below the required 25 there. You have Mr. Ross's petition packets here. They consist of 1, 2, 3, 4 pages of
I
signatures.
only got 2, so we're gonna get 4.
And I don't have the full packet either.
There, so you guys can see.
It's okay. I think it's probably okay.
And so each petition page has 10 signatures on it, though if you look at page 4, it does look like while there are 4 spaces filled out, one of the lines, signature 3, I believe, is crossed out. It seems to be a duplicate of signature of 4, so one was crossed off, so that would actually bring it to not 34 signatures, but 33 signatures. They're obviously for testimony from the objector, saying that it's 33 instead of 34. So in light of that, then in order to meet the requisite 25 signatures, Mr. Ross would need to provide evidence showing that 2 of the objected signatures are actually valid. Okay, does that make sense? So that's what you guys have to go through and discuss. So of the 10 objections, if you find 2 of them to be valid, then Mr. Ross meets the 25. If you find that you only need only one of them is valid, he's still gonna be short, but he lands at 24, okay? So you have to find two of them are there, that's kind of maybe a simple way to think about it. Two of the objections, Mr. Ross has already admitted are not valid during his own testimony. And that is the cancel signature, and then there was page 2, line 6, where he indicated that the voter didn't change, didn't update their registration information, so that was page 2, line 6. So two of those, Mr. Ross has already objected or admitted should be sustained there. The next one then is the signing of the petition page. Who's signing two different parties' petition page. Right. So, and I think there we have potentially some conflicting law there. Attorney Miller has cited a case that Patton versus Illinois, that she has, on behalf of her client, testified that provides that you can only sign one party's petition page. I'm in agreement with that. However, she also indicates that the case stands for the proposition that the timing doesn't matter, okay? My understanding that then there is a different case, also out of the first district, that says that you can't sign more than two candidates, two different parties' petition page, but then also goes to draw the distinction that timing of when they sign does make a difference. There, in that case, the Watkins case provides that whoever you sign first is the one that's valid, doesn't disqualify the signature on both petitions, it still makes one valid there. So we have a little bit of conflicting law on that there, or what appears to be. I don't, do you have the Patton case by
I don't
chance
have a
with
copy
you?
on me, actually.
Okay, so, unfortunately, I'm not gonna have an opportunity right now, at least, to review it, unless we wanna take a recess so that I can go look it up and take, which is fully, the board can do that.
Something I think we need to know.
Okay.
Well,
Well,
it's a matter of two different cases.
Yeah.
So it's a matter, it's not like
Okay,
it's a cut and dry thing. I mean,
Typical law.
in front of me, I have the Watkins, section 710, the Illinois election code, talking about what is a qualified primary elector. And in quotes, it says, where an otherwise qualified voter has signed the nominating petition for more than one party, the signature appearing on the petition first signed is valid.
Okay.
That's what it says.
So that's the Watkins case, we obviously then have a conflicting, a different, arguably, division that there that says that it's, the timing doesn't matter. So let's put a pin in that one, for now, and then I can go look up both
Well, I have a
cases.
question.
Sure.
If we need to find two that are valid, is there any besides Ms. Johnson's that we're considering might be valid?
Well, we can certainly approach it from that standpoint as well.
Is it kind of a moot point? If
Understood.
we can only come up with 7, why haggle over the 8?
Understood. So then the remaining objections are about whether or not those voters are actually in the third ward. I think Mr. Ross has presented evidence to you showing that these people are registered voters at those addresses, right? Attorney Miller, I think, has indicated that she agrees. She doesn't disagree that these are registered voters at that address. What boils down to is whether or not that address is actually in the third ward and there. And
It's easy
so,
enough to show.
Attorney Miller has provided, and again, maybe we can pull up the computer again, provided evidence showing that these addresses are no longer in the third ward there. I don't, again, this is you guys with charge. In fact, I don't recall the evidence by Mr. Ross saying that they are.
I would agree.
I think he said that they are registered voters at
This
the
is pretty
address.
simple. I walk up and I ask the county clerk, look in the computer, tell me what ward they're in.
Well, that's the problem.
That's-
Yep.
This part
That's kind of,
is the fact that I don't think that the county, just as those voter registration cards don't tell you what ward you're in, I don't know if the county clerk at this time knows
They don't.
what ward.
Even though my registration card tells me what ward. So, but I can't go up there and they can't tell me what them addresses are at. The clerk's office, which is the one that makes them up.
They're in the process of updating that information because they had to just run the last election. So now the new ones are going out for the next election, but they have to get that all updated.
So it's not updated.
So the wrong, I think my understanding as well, and a part of my diligence as the board attorney, is that the county clerk's records are not up to date at
They're
this
not-
point.
They wouldn't be good evidence right now because they're not.
She-
up-to-date.
They're not giving
provide it.
evidence, yeah, they wouldn't
They wouldn't
provide it, because they know they're not up to date.
If it's available, I can get it. If
That's-
it's not
it's
available,
not.
I can't get it.
Right.
So it's up to us to determine
That's why,
where.
it's a comparing the ward map
Okay, so take the
to the
map,
address,
drive out there.
find out where the address is.
Which is,
and then-
this is what Attorney Miller is saying.
But that doesn't have street, it doesn't have house numbers on it. So it's difficult to look at that and look at the addresses they have here and say whether it's on this side of Adams Street or on that side of Adams Street. So the only way I can do it, and if you want to get somebody to replace me, fine, is I drive out and look at the address and look and see which
Well-
side of Adams Street it's on.
And I don't think you have to do it, Don, personally, not necessarily would be the role, you know, you're a trier of fact, you would sit here. You can certainly, you know, and you get the benefit of not having to go out and do it yourself there, but you can certainly, you know, request data, you know, subpoena data that would show that, and that's something that's certainly either from the ward map, you know, if it's blown up enough, you can see where the ward extends to, you know, north side of the street, south side of the street, or whatever it is, and then where the particular property.
there are
is
two
located.
maps on the website that we could cross-reference and sit here and do it.
Yeah.
So B, C, and D are all living in the same house.
Yes.
And so they're claiming that one is right here. E is in another house, which is 2, which would be right there.
And then 3 and 4 are right next to each other.
Yep. Because I don't think it's a question of, do they live there? We know they do. Are they a registered voter? We know they are.
It's whether the maps change their ward.
Correct.
And again, it's, you know, my office also then will do the comparison, pulling up the ward map.
You did that?
Yeah, my
That's
staff
what
did
this
as
is.
well. That's what this is.
Oh, that tells what it is.
Yeah.
All right, I'm sorry.
So,
Answer the questions.
so, from what we can tell, it doesn't look like these addresses reside in the third ward. They look like a change of the ward map did put them into the 5th ward instead of the 3rd. There. Again, certainly,
Right now, we can only verify one, that lady signed it first.
Mhm.
pardon me.
It seems to me that we will be left deciding if there's 23 signatures or 24 valid signatures. And if it's not 25, why do we debate any further?
I have a question for the other attorney. You brought up whether she signed a Democratic or his. Does that matter in state law, whether it was Democrat or?
No, the only thing that matters is that it's 2 separate parties.
2 separate
Yeah, so it
parties.
could be the Green Party, it could
Okay.
be the
But
Republican
that,
Party.
that doesn't really, it's just a matter of whether, which one
case
she
law?
signed first.
Well, and that depends on which case law you follow, but essentially, as I was pointing out, what you're doing is you're declaring that you're a member of a particular party. And by doing that, that is your party for that cycle, and so, that's why it matters. Because they just don't want people interfering with other parties' primaries.
All right, thank you.
So, the fact that 2 signatures, Mr. Ross says, admitted are not valid, there. And then we have, the other ones that are actual standpoint, but it does not look like it.
Okay.
Okay, likewise, you've heard testimony from Mr. Ross that says that, hey, these are registered voters that live at this address.
Yeah.
But you do not have evidence from Mr. Ross or anything that is provided that shows, well, are these homes in the third ward, fifth ward, fourth ward? He has provided evidence to do those parcel that
It's not
says.
the fourth word, I guarantee you.
Okay. He has provided evidence so that says that these people do live here and they are registered voters. Okay. So from there, and then the one about who to sign first, that is, you've heard evidence that says that, hey, timing does make a difference, and she signed first. Evidence of a case that says that it does not, timing does not make a difference.
Sounds like it's immaterial anyway.
So. So again, I would ask each member to at least provide some statement, as to, where you guys are thinking, what you guys are thinking, where you're coming from, where you're leaning. So that way we'll then be able to at least move to votes on these objections.
Well, I'll start by Alderman Ross's own admission. Obviously, the two are removed. I would go with the case law of walk-in, that who signed it first. She's here to tell you that she signed Ross's first. As far as the other 7, we don't really have evidence of, we know they're all registered, we know that they are in that home, but it appears by the evidence before us that they are in Ward 5, not in Ward 3, which is totally.
Signed in good faith, but.
Yes, signed in good
Yes.
faith, collected in good faith. But when you look at the location, it shows that they're in Ward 5.
Are there additional thoughts? Would you echo those thoughts?
I have to agree. If you said them, what you laid out, we can only add one, he needs 8 of them, and we only can add 1. Or I mean, we can have 1, but he needed 2 added, right? He needed 33, and we can earn 23. And I agree with, the lady signed it first, I don't care about the party, that's 24. But none of the rest of them, and the one's canceled, and all the rest of them live there.
I just don't feel we have 2 votes we can squeeze out of here to proceed.
Frustrating.
Yeah.
Now you can drop your order.
They're so, okay, let me see how we can do this as a motion then. So, I guess the motion would be that, a motion to find that Mr. Ross does not have the requisite 25 signatures required to be on the ballot, that he only has 24 valid signatures, and with regards to the specific objection that canceled registration that is sustained,
I have a question on that. The determination of cancellation, is there any case law that would say, a good faith statement that, because I never knew that existed. I think most people don't know
I
that
bet most
exists.
people in here didn't know other than the 2 attorneys.
So is there anything that stands with that?
you're either canceled or not. I mean, what we're looking at is status.
Right.
What is your status at that time, irrespective of your knowledge of what you are or aren't?
And in good faith, obviously, that individual wouldn't have,
Yeah.
I wouldn't have known.
Just because you don't vote twice, you're out.
Well, it's kind of an interesting process, so they do try to get a hold of you, they send you your voter card, and it gets bounced back. Once it gets bounced back, they try to do a forward email address to see if you have moved, and you can forward it on, and then you can change your address. If you don't change your address, and you don't get that mail and you don't vote, you become inactive for 2 years. Then they try to do the whole process again, and if you still don't vote, then you get canceled.
So the clerk's office does notify.
Yep, and they try very hard to notify, they have 4 or 5 steps they have to take.
Yeah, and that's law required to
Yeah,
do
that's
that?
the National Voting Registration Act of 1993.